Good day and welcome to the Loss Control webinar series. Today's presentation is titled 7 Key Liability Coverage Issues. I'm Courtney Stevens, an attorney in the Loss Control Department at Medmarc. On behalf of Medmarc and today's presenter, Randy Maniloff, thank you for joining us. Randy is an attorney at White & Williams, LLP in Philadelphia, where he represents insurers in coverage disputes under a host of policies. He is also the co-author of the book, General Liability Insurance Coverage, Key Issues in Every State, now in its 3rd edition. Randy is the publisher of Coverage Opinions, an electronic newsletter with over 22,000 subscribers. Coverage Opinions focuses on important new insurance coverage decisions, takes a look at the lighter side of law, and includes Randy's interviews with the most famous lawyers in America. Randy is also a frequent contributor of articles to the Wall Street Journal editorial pages on legal topics. Lastly, in his spare time, Randy is a stand-up comic. He has performed at some of the most prestigious clubs in the country, including Caroline's on Broadway and the Second City in Chicago. With that, I am pleased to turn things over to Randy, who will begin today's presentation.
Thank you, Courtney. I appreciate that very much, and thank you for the invitation to speak today. And also, I want to thank Heather for doing all the technical stuff that is required to make something like this happen. So I appreciate that very much. Good afternoon, everybody. As Courtney mentioned, I'm an insurance coverage lawyer, and I represent insurance companies only. My whole career, I've only ever represented insurance companies. And so, when you do that, you sort of you bring things from a certain perspective. But I'm not here to argue, this shouldn't be covered or that should be covered and things like that. I just want to discuss some important liability coverage issues, and this isn't some sort of advocacy argument on behalf of insurance companies or anything like that. So I'll do my best, because normally that is what I do in a lot of times in webinars, but that's not what I want to do here today. Medmarc, of course, writes, among other things, an excellent medical products policy, and I'm very familiar with that policy. And when you think about a medical products policy, you think about how does it compare to a general liability policy? That's kind of the general liability policy. The ISO CGL general liability policy is kind of the standard bearer of the liability world. And then you say, well, how does a medical products policy differ from that? And I want to talk about that really briefly, how they differ. But the reality is that they also have many, many similarities in terms of the legal issues and in terms of how they function. So I just want to talk very briefly about some of the differences between just a general liability policy and a medical products policy. But the bulk of my presentation is going to be on the similarities. And in that regard, I want to focus on issues that are sort of overarching. A lot of interesting coverage issues are very limited. It requires certain narrow facts for them to be relevant. And, I don't want to spend time on those today. I want to focus on issues that come up repeatedly, that have the opportunity to come up in many, many claim scenarios, as opposed to just sort of very narrow claim scenarios. As Courtney said, please feel free, or it might have been Heather, I apologize. Please feel free to send questions all throughout. I prefer to take questions throughout. I think it's better when questions are discussed in the context of the discussion to which they're related, rather than at the end. So feel free to send them in, and I will do my best to answer them as I'm going through. As far as downloading the PowerPoint goes, you're not going to want to do that. I can assure you this PowerPoint is not going to win any awards for PowerPoints. I'm not a big fan of PowerPoint. I've always felt that webinars are best done sort of listening, and a webinar is designed to raise issues, raise awareness of issues. Seeing a few bullet points on the screen isn't going to achieve that. I think it's better to just listen and then think about issues and kind of put them in the back of your head as things to remember and look at. And after the webinar is over, no one's looking at bullet points. So I'm not just a big fan of PowerPoint. So you're not going to. There's nothing to download, I can assure you that, but I promise what the PowerPoint lacks in substance, my presentation will make up for. So the first, so really what I want to talk about is sort of the similarities and the differences. But first, let me talk really briefly about the differences between a general liability policy and a general CGL policy. I'm looking at the Medmarc's new products completed operations liability coverage form. And, if you look at the insuring agreement, it starts out pretty similar. The Medmarc policy is, we will pay those sums in excess of the deductible. Now, you don't have that excess of the deductible language in a CGL policy, but we will pay those sums in excess of the deductible that the insured becomes legally obligated to pay as damages because of bodily injury or property damage. That, right off the bat, is pretty much the same language as an ISO CGL policy, that you'll pay damages because of bodily injury or property damage to which the policy applies. But then, right away, right after you get to that, the fundamental requirement that you need bodily injury or property damage, and I'll talk about that a little bit later, is that then the bodily injury or property damage has to be included within the product's completed operations hazard. And that's really the crux of where a medical products policy and a CGL policy differ. The CGL policy is extremely broad in terms of there's no limit to what's covered as long as it's caused by an occurrence and as long as it's not excluded. You have in a medical products policy the qualification that the bodily injury or property damage has to be within the product's completed operations hazard. It has to be caused by an occurrence, which is in the medical products case, that's the same as in the CGL case. The Medmarc policy is claims made, which is different from a standard ISO policy, which is pretty much always occurrence-based. But that's only a difference in the reporting issues. That substantively, that doesn't make a difference. That's only a difference in the notice issues. So, the big difference then between the medical products policy and the CGL policy is that the CGL policy provides coverage for anything caused by any bodily injury or property damage caused by an occurrence unless excluded, and in the medical products policy it has to be within the product's completed operations hazard. So that's really the biggest difference. I mean, the main issue being that, a premises liability claim, someone slipping and falling on a banana peel, would not be covered under a medical products policy because that's not within the product's completed operations hazard. Whereas if you look at the Medmarc policy, something has to be bodily injury or property damage occurring away from your premises and arising out of your work or your product. All the different definitions in a medical products policy are tied to the product's completed operations hazard, and those are all tied to something arising out of your product or your work. And then the next question becomes, well, what's your product? What's your work? And then you get to the definition of your product, and that deals with the medical devices, drug, biologic, in vitro diagnostic, cosmetic, soap, nutraceutical, all the things that a company that needs a medical products policy would want. So that's really the crux of the medical products policy. It's a CGL policy with the qualification that it has to be arising out of the completed operations, product's completed operations hazard, which is then defined as something arising out of your product, and then your product is defined as a medical product. Now the Medmarc policy also has some extra provisions for clinical trials and gosh, I'm losing my train of thought here, and medical monitoring. But those are completely, obviously only unique to the medical product situation. Okay, so with that background, we'll jump into the liability coverage issues. And these liability coverage issues that I'm going to discuss are ones that are relevant to both the medical products situation and the CGL situation. So they overlap. So really the crux of the seminar today is to talk about the similarities between the CGL policy and the medical products policy when it comes to overarching coverage issues, overarching legal issues. Webinars are tough to do. If you've never done one, you have to think about, speaking to lots and lots of people on the phone, a big audience that you can't see. You don't get any feedback. You don't get any nonverbal cues. People aren't nodding. Geez, is anything I'm saying getting through? I mean, it's like kind of like being at my kitchen table at night. You just don't know if anyone's listening to you or not. So what I did was I actually have an audience here in my office. I brought an audience in just so I could have the benefit of seeing people and looking at people. So in my office is the audience for my audience for the webinar, because I can't see you guys. The best thing about having these guys in your audience is that no matter what you say, they nod their head up and down. All right. I mean, it's awful. I mean, you tell a joke and you have no idea if anyone's even laughing. So anyway, all right. So here's where we get into the coverage issues, and I picked these coverage issues with Courtney. We were looking at issues that again, are overarching, that are not really narrow, that have a lot of applicability. And, the duty to defend is far and away, hold on, before I get there, let me make a comment. The issues that I'm going to discuss here are all of them are very, very state-specific. General liability coverage is extremely, extremely state-specific in so many ways. I mean, whether or not a claim arises on one side of the bridge or on the other side of the bridge can be the difference between coverage being owed for $10 million or coverage being owed for nothing. So, it's state-specific in a very important way, all these issues. So you have to keep that in mind, the choice of law component here. One big mistake that I see with choice of law is that I'll get a call from a client and they'll say, hey, we have this case and, is this covered in Montana? And the first thing I'll say would be, well, why Montana? And the usual response will be, oh, well, that's where the complaint was, But the reality is that choice of law is generally determined by the law of the state where the policy was issued. So, the address on the policy tends to be the choice of law. So if, the lawsuit was in Montana, my clients will say, well, what's the law in Montana on this? Is it covered? And I'll say, well, where was the policy issued? And they'll say, South Dakota. So the reality is we're dealing with more of a South Dakota issue than we are a Montana issue. So just keep that in mind. Choice of law is key, but on top of that, it's really where the policy was issued, not necessarily where the claim arose for choice of law. So duty to defend, again, obviously the big issue with duty to defend is, there's a duty to defend if there's any possibility of coverage, if you look at the complaint and there's any possibility of coverage. But that's not really a significant duty to defend issue. Everyone knows that the duty to defend is really broad, and if there's any possibility of coverage, then there's a duty to defend. The real issue in duty to defend that you have to think about is, what's the test for determining duty to defend? And there's two general tests are the four corners of the complaint, which is where you just look at the complaint. You can't look to the left of the complaint. You can't look to the right of the complaint. Just focus on the complaint, focus on the policy, and if there's a potential for coverage based solely upon the complaint, then there's going to be a duty to defend. And every state starts with that test, the four corners of the complaint. And some states stop there. They say, okay, this is the duty to defend, four corners of the complaint. Other states say, okay, we're going to look at the duty to defend based on the complaint, but suppose that the complaint doesn't trigger a defense. What about other extrinsic evidence that's available? Would that trigger a defense? And some states, many states, in fact, permit the use of extrinsic evidence to determine if there's a duty to defend. Generally, courts do not allow an insurer to look at extrinsic evidence to deny a duty to defend. It's usually just a one-way street. So an insurer may be obligated to look at extrinsic evidence to find a duty to defend, but then not look at extrinsic evidence, not be allowed to look at extrinsic evidence to disclaim a duty to defend. And that, to me, is the most important issue. Whether or not there's a duty to defend is the number one issue in liability coverage. First of all, it comes up in every single kind of case, regardless of the policy. As long as it's a liability policy that has a duty to defend, the question of whether or not a defense is owed is going to be there in that case. It's the first issue that comes up. It's right out of the bat. Sometimes, there may be a real quick deadline to answer a complaint if you don't get an extension. So the insurer has to make a decision very quickly if they have an obligation to defend. And, as a practical matter, once an insurer is defending a case, they now have a financial interest in the case, and now they're spending money, and now, perhaps they want to not spend the money defending the case. Even if the case is not meritorious, the insurers look at things in a very financial way, and they may say, look, this case is not meritorious, but as a practical matter, maybe we want to get rid of it because the defense costs are going to be outrageous. So the duty to defend is a big issue for insurers because it gets them in the game in terms of having to think financially about what to do with the case. Do they want to defend it to the hilt? Do they want to maybe try to resolve it? And they're going to factor in those defense costs in doing that. Insurers really need to tread lightly about disclaiming a defense. The consequences for disclaiming a defense and being wrong are pretty significant. Varies from state to state, but it could be, obviously you have to pay the defense costs that you didn't pay, but that's just the starting point in many states. There may be, attorney's fees that you have to pay for the other side. You may even lose your coverage defenses if you don't defend, and there should have been a duty to defend, and if there are now defenses that apply to indemnity in a handful of states, you lose those defenses. So the duty to defend is, in my opinion, the most important liability coverage issue out there. And the courts that allow for the duty to defend to be determined based upon extrinsic evidence, they're really, really focused on the fact that a liability policy is what they consider to be litigation insurance, and they're going to do everything that they can to get that defense for an insured. And and other courts look at it in terms of why should the duty to defend be tied to sort of the vagaries or the pleading or the manner in which the underlying plaintiff pled the complaint. Why should the insurer's entitlement to a defense be tied to the way that fortuitously the underlying plaintiff chose to draft the complaint? So that's sort of the rationale for the duty to defend. Okay, so the next issue. Okay, don't get excited about what the next slide's going to look like, because it's that one. Is coverage for pre-tender defense costs. 1 second here. Let me do something here. Okay, and pre-tender defense costs. Now, late notice is coverage for pre-tender defense costs is kind of a close cousin to the late notice issue. Late notice is obviously, when there's been a delay in providing notice to the carrier of a claim, putting aside, assuming that the notice obligation under the policy was satisfied. Then the question is, okay, the notice obligation under the policy was satisfied, but the insurer did not comply with that in a timely manner. And for the most part, insurers have a difficult time disclaiming coverage based on late notice. The courts almost not unanimously, but substantially require that there be prejudice by the insurer to say that they're going to disclaim coverage based on late notice. Prejudice being that the insurer's rights were harmed by the fact that there was this delay. And prejudice is hard to prove. Consider a case with, let's say, 8 months notice or 7 months notice. That's late notice. There's no question about that, especially if a suit's been filed. So a suit's been filed and there's been we'll just make it 6 months. 6 months delay between when the suit was filed and when the notice comes in. Now, that sounds like a real bad situation, but if the insured was defending themselves, let's say the insured went out and hired their own lawyer to defend themselves, then it's real tough to prove prejudice, because the court would say, well, yeah, the insured didn't know about it, but the insured hired a lawyer and they defended the case and they did a good job defending the case. And if you, insurance company, had hired a lawyer, you probably would not have you probably wouldn't have done anything differently, so especially in the early stages. So, and in the world of litigation, 6 months is not that far along. So it's hard for insurers to prove prejudice when there's been late notice, because the reality is that, there may have been a defense or witnesses are still there. The insurer has not lost any rights, so to speak. That's really the test. However, the close cousin to that issue is pre-tender defense costs, and this would be a situation where, taking that example with the 6 months, would be, okay, there was 6 months delay, and during that 6 months, the insured defended themselves, incurred all these defense costs, and now they want to get coverage for it. And in that situation, courts have been extremely receptive to the insurer argument that they do not have to pay for the pre-tender defense costs. And that could be significant. Litigation, especially in the early stages, can be very, very active. A complaint's been filed, everyone's running around, doing stuff, incurring expenses. The fees can be generated. The fees that can be incurred in the early stages of litigation can be quite substantial. And most courts have said, for purposes of pre-tender defense costs, the insurer does not have to prove that they were prejudiced. Simple rule, black letter rule, bright line rule, that an insurer does not have to pay for a defense that they didn't know about. So, and some of the courts that say that are very, very strict for insurers on late notice. They can't disclaim coverage for late notice, but those same courts turn around and say, but for pre-tender defense costs, absolutely. So, the risk, if you're in charge of putting people on notice of claims, the risk of delaying is substantial when it comes to the pre-tender defense cost world. Okay, next is the insured's right to independent counsel. You have a situation here where the insured is entitled to a defense. The insurance company has said, okay, you're entitled to a defense. And now the question becomes, well, how do you do that? And insurers typically turn to someone on their panel and they say, in this state, the case is pending in such and such state. We have panel counsel in that state. We've used him or her in the past. We like them. They're good. They're competent. We have a rate structure with them in place. We're going to send it to this firm that's on our quote panel. And some policyholders object to that on the basis that they feel that this is the insurer's lawyer. This is the insurer's guy, and they may not handle the case in the best interest of the insured. The theory being that the panel counsel, it wants repeat business from the insurance company, and therefore it might handle the case in such a manner as to slant the case or try the case in a manner that steers it toward no coverage as opposed to one that steers it toward coverage. And courts have said this. It sounds like a complete indictment of panel counsel about their ethics, but lots and lots of courts have said that. They've said that if there is a combination of covered and uncovered claims, and if the defense lawyer could theoretically, quote, steer the case, I don't even know how you do that, but courts say it, if you could steer the case towards the non-covered claims and theoretically get all the covered claims dismissed, then because of that ridiculous possibility, as it is, that the insurer is entitled to independent counsel. Some states make it simpler. They say if there's a reservation of rights, automatically we're not going to ask any questions that an insurer is entitled to independent counsel. There are a handful of states that are like that. Then some courts say, well, we trust defense counsel. They would never do anything like that. There's never a right to independent counsel. But most states say that if there is this conflict, if the reservation of rights letter creates a conflict of interest, then the insured is entitled to independent counsel, meaning that they can go out and choose their own lawyer, and the insurance company will pay for it. So if that happens, then there's the question of, well, how much does the insurance company have to pay for the independent counsel? Because as often happens is that the insured goes out and hires a lawyer that is more expensive than the panel counsel, because insurance companies have arrangements with their panel counsel, and usually the rates are reduced because of the relationship that they have, whereas the insured goes out and hires somebody that's more expensive. And this can be a real dispute. I'm sure everyone listening to this webinar has perhaps dealt with this issue. It comes up a lot. It's not an easy issue to deal with. Some policies, courts have said that insurers should put something in their policy to address this, to say, look, if we have if we have the obligation to provide independent counsel, and if that's the case, then we'll do so, and we'll pay the rates to your independent counsel that we could have paid to our panel counsel. The Medmarc policy has a provision like that, and I think that's a reasonable provision. Lots of courts have endorsed a provision like that, saying that that's the way to deal with this dispute. And so that's one way to deal with it. But it's a contentious issue. There's no question that it is a contentious issue in terms of how to deal with the rate issue. In general, the issue is the answer is usually somewhere in the middle. The insurance company says that they want to pay, X, and then the insured comes back and says our independent counsel is 3 times X. Usually the answer is somewhere more than what the insurance company wants to pay, and somewhere less than what the insured's own attorney wants to charge. So. But again, these are real tough issues, and I think the Medmarc policy does a good job of taking that off the table by and there are some states like in California and Alaska have said by statute that the insurance company only has to pay the amount of the independent counsel rate that it could have paid to their panel counsel. Let me see. There's a question here about what are some states that say automatically that an insured is entitled to independent counsel. There's a reservation of rights. There are a few of them. The main one is Mississippi is one that has that under the Mueller case. Massachusetts has one. There are a few others, but those are the two Those are the two that you see a lot. There are probably a couple more than that, but I know off the top of my head, Mississippi and Massachusetts have that rule. All right. Let me see here. Let me take a drink. All right. Excuse me. Moving along here. Okay. We talked in the beginning about the fact that every general liability policy, every medical products policy, you need bodily injury or property damage, and the question comes up a lot. What is bodily injury? I mean, in most cases, it's not that hard to figure out what is bodily injury. I mean, if a person is holding their left arm in their right hand, then there's a pretty good chance that that's bodily injury. But it can be more subtle than the obvious situation where somebody is killed or physically harmed. The question becomes, is emotional injury bodily injury? That's the big issue that you see in tort cases, where somebody alleges that they were emotionally injured by some act of the defendant. And the majority, and keep in mind, most courts define, most policies define bodily injury as bodily injury as injury, sickness, or disease. And the courts have said basically that the majority view is that emotional injury is not injury, sickness, or disease. A handful of courts have said the opposite, New York being the most prevalent one. A handful of courts have said that emotional injury by itself is bodily injury. That's the minority view. But there are really two majority views here. There's the majority view being that emotional injury is not bodily injury. That's sort of majority view number one. But then there's a subsequent majority view, which is, okay, emotional injury is not bodily injury, but emotional injury that results in physical manifestation of that emotional injury is bodily injury. For example, if someone alleges that they were emotionally injured by a defendant's actions, by an insured's actions, and that emotional injury led to physical manifestations such as heart palpitations or they can't sleep. Courts have debated on whether or not being able to sleep is physical manifestation, but they've lost their hair. Courts have also debated that. But the big one is like if you have chest pains, or stomach problems or something like that because of the emotional injury, then most courts would say that emotional injury with that physical manifestation is bodily injury. So that's now some policies solve this problem by specifically saying that emotional injury is bodily injury, so you wouldn't have to deal with this physical manifestation issue. And some policies deal with it by endorsement. But in general, in a standard situation where it doesn't define bodily injury in that way, you're going to be up against this test being that if there's physical manifestation of emotional injury, then there's going to be it's going to be considered bodily injury. Let me see here. Okay, wait, hold on. Let me see here. I know this isn't New York specific, but I'm reading a question here. I know this isn't New York specific, but I believe in New York, the injured party reporting late cannot prejudice. Are you familiar with differences between which party reports, injured party or insured? You know what? That's a complicated issue. Let me kind of address that. Let me sort of address that offline. That's more than I want to get in here. I don't want to. It's a really, really specific issue. So let me do that. Okay, let me move over here to coverage for innocent co-insured. This is sort of what I call the any insured versus the insured issue. The key to insurance coverage, the overarching rule of all insurance coverage, is that the policy language controls. The policy language is king. You're going to have that in every case. You can find a court case that says that in absolutely every state. Policy language is the key. Nothing else matters and all that stuff. And nowhere, in my opinion, is that put more to the test than in the innocent co-insured situation. This is a situation where the policy says, it's usually in the form of an exclusion, but not always. The policy says that there's no coverage for the criminal act of any insured. or the policy says there's no coverage for a criminal act of the insured. And it would be very easy to read those two and not see any difference or not pick up on the difference. And the difference between a policy that says criminal act of any insured versus criminal act of I'm sorry, I just was distracted by something. I beg your pardon. So the criminal act of any insured and criminal act of the insured, the significance is huge, and let me explain why. Let's say, let me give you an example here. Let's say you have a very typical case in the homeowner's context, but this doesn't have to be homeowners. This comes up in so many scenarios. You have a situation where the parents and they have a child living in their house, and the child isn't insured under the policy because he's a resident of the house. The child assaults the neighbor. So the child assaults the neighbor, and the neighbor sues the parents, and the neighbor sues the kid. Because remember, the kid isn't insured under his parents' policy. Now, and there's a policy, and let's say the assault was criminal, and the policy says that there's no coverage for the criminal acts of the insured. Well, now you have a situation where the insured is the insured seeking coverage. So there's no coverage for the criminal acts of the insured, meaning that the kid who committed the assault is not covered because that's a criminal act of the insured. However, there's still coverage for the parents because the parents are not the insured, are not the ones that committed the criminal act. The parents are only being sued for being negligent for failing to prevent the child from committing the criminal act. So if you have that there's no coverage for criminal acts of the insured, there's only going to be no coverage for the criminal act of the insured that actually committed the criminal act. The parents did not commit a criminal act, so the criminal act exclusion would not apply to them. But if the exclusion said criminal acts of any insured, then it's a whole different story. You get the complete opposite outcome, which is that any insured is the kid. He committed a criminal act, so therefore there's no coverage for the parents as well because it's not being looked at in terms of who committed the criminal act, as in the first example. It's being looked at from the standpoint of if any insured committed a criminal act, and because any insured, being the kid, committed a criminal act, all the insureds are precluded from coverage. It's absolutely staggering how dramatic any insured versus the insured is. And, I mean, imagine a policyholder, imagine an insured being told that there's no coverage for a multi-million-dollar claim because the policy says any insured and it does not say the insured. I mean, if, you know, that would be sort of it's significant. The law recognizes it as such. There's a huge body of law on the difference between the insured and any insured. But to a policyholder, it's really, really hard to see that. So, you know, that's something that if you're looking at policies, it's a very, very subtle thing. But I think you want to, you know, keep in mind that when exclusions talk about any insured, they're much broader than if they said the insured. Also, then there's a second part to this whole thing, which is that there's a separation of insureds clause in a liability policy. And many courts have said, okay, we get it. Any insured and the insured are two different things. However, we're not going to apply it that way because the separation of insureds clause says every insured is treated as if they were a separate insured, as if the policy were issued to them individually, with the exception of limits and a couple other things. But for the most part, the separation of insureds clause says the policy shall be treated as if it were issued or as if it were issued to each insured separately. So therefore, how could that have any meaning if you were then going to say that the acts of one insured would affect coverage for the acts of another insured? So those states do not recognize this distinction between any insured and the insured. But lots of states also do recognize, and they say, notwithstanding the separation of insureds clause, we're going to uphold the distinction between any insured and the insured. So it's a little bit, you know, tedious, but the significance is huge. Let me look real quick here, make sure there aren't any questions I'm not ignoring here. All right, so let me go back real quick back to the mental anguish issue. So mental anguish wouldn't be covered only if bodily injury causes emotional injury. That would be correct. Yes, under the classic, yes, the bodily injury that causes emotional injury, that's a different story. Emotional injury is a component of bodily injury, but bodily injury isn't necessarily a component of emotional injury. I think it's probably the best way to explain it. But so yeah, mental anguish standing alone would not be covered under most scenarios. It would only be mental anguish that results in physical manifestation or bodily injury that also causes emotional injury. I hope I answered that. Let me. Okay. Where are we here? Okay, wait a minute. Insurability of punitive damages. This is one of a really, really misunderstood issue. In many ways, I often hear people say, are punitives covered in such and such a state? You get that question all the time. And the reality is that coverage for punitive damages is rarely a yes or no proposition. But it's always presented as a yes or no question. Are punitives covered? Yes. Are punitives covered? No. However, the question of coverage for punitive damages is usually much more nuanced than that. But before I get to that, there are two competing theories in general on coverage for punitives. One is that punitive damages can never be covered because why should somebody if somebody does something horrible and they get the benefit of insurance for their punitive damages, then they're not really being punished because they would have able to pass the bill on to their insurance company. So it would violate public policy, they say, to allow insurance coverage for punitive damages, as opposed to, and then they also say, well, it would encourage reckless behavior. If insurance coverage was available for punitive damages, it would encourage people to go out and do bad things. Other courts scoff at that, and they say, that's ridiculous. The notion that people will go out and act irresponsibly because there's insurance for their irresponsible actions is just ridiculous. There's no proof of that, regardless of whether or not punitives are covered. People still do reckless things. People still drive drunk. People do all the things that cause punitive damages, even in states where those punitive damages are not covered. So the fact that people act more carefully if their punitive damages aren't covered is ridiculous. And those courts also look at it and say, look, it's a contract issue. If the policy doesn't exclude punitive damages, the policy covers quote damages are punitive damages, therefore they come within damages. So those are the two competing schools. But the courts that allow coverage for punitive damages, sometimes they do it, it's not always yes or no. Usually there is some sort of a distinction. Usually there's some sort of a distinction in terms of the state of mind. Being found liable for punitive damages usually is a question of what was your state of mind? What was the defendant's state of mind? What was the insured's state of mind? Were they acting recklessly, intentionally, grossly, negligently? All kinds of different standards of conduct out there. And many, many courts tie punitive damages to the coverage for punitive damages to those different state of mind considerations. And that's something that gets lost a lot in the question of coverage for punitive damages. Another thing that gets lost is, a lot of states say, there's no coverage for punitive damages, and that's true. However, there is coverage for vicarious liability for punitive damages, meaning that, if a company, let's say a company is found liable for the actions of their employee, the employee does something really, really horrible, and the punitive damages are assessed, but there's assessed against the employee, and they're also assessed against the employer for failing to prevent the employee from doing this, then often the courts will say, well, there's no coverage for the bad actor because that would be giving him insurance for his own bad conduct, and that violates public policy. Why should he get the benefit of insurance for his bad conduct? But the same rationale for doing that doesn't always apply to the employer. The employer, they're simply liable for the actions of their employee, and the employer, their liability is more along the lines of negligence for failing to prevent it rather than actually having that same intentional component as the employee. So those are the two sort of schools of thought on punitive damages. So I would just caution you to keep in mind that it's not always as simple as, yes, punitives are covered or no punitives are not covered. the last issue that Courtney asked me to talk about is faulty workmanship and occurrence. Now, this is not really an issue that's going to come up in a medical product situation per se, but it's probably the biggest CGL issue out there right now in terms of construction defect. Maybe you're dealing with this in other accounts that you have that are not necessarily medical products, but this is the most contentious. This and the pollution exclusion are probably the two issues that I have seen more litigation over than I've ever seen in my entire career. Is whether or not there's coverage for faulty workmanship. It's extremely state specific in terms of one state can be covered, and then you cross the border and the exact facts, the exact policy language, it's not covered. And the big question being that whether or not the big issue on it is sort of the majority rule is that there's no coverage for an insured's faulty workmanship. If an insured puts in a window, let's say, and the window is bad and the window has to be taken out, then there's no coverage for that. That's the insured's own product or their own work. However, like let's say a stucco installer, that the stucco's bad, they have to replace the stucco. But usually there's some consequential damage caused by the bad work. So while there may not be coverage for your own work, the insured's own work, or the insured's own product, the consequential damages caused by the product is generally considered an occurrence. So, for example, if you had the bad windows, the insured has to take the windows out and put in new windows. That's not going to be covered. But the water damage that might have been caused by the bad windows, the water damage to the inside of the house, that is usually covered as an occurrence. So that's the very, very quick analysis of an issue that is absolutely monumental in terms of coverage litigation on the CGL front. I think that's, let me see, let me check for questions and all that. What if the faulty workmanship happened at the factory when the medical device was being made? Let me think about that. What if the faulty workmanship happened at the factory when the medical device was being made? Well, there are a few things I could say about that. One would be that there's no it wouldn't, the product did not leave the premises, so I'm not sure if that would be triggered as for a medical product situation. But if it's under a standard CGL policy, you'd have to obviously have bodily injury or property damage for sure. It hasn't left the premises, or it hasn't left it's not finished yet, so it's not within a completed product. So I guess if you want to, the person who asked that question, if you want to give me a call or that, or send me a question about that, because I'm not sure if you're talking about a faulty a medical product situation or just a general liability situation. Also, if there was bodily injury at the factory where it happened, then it may be a question of there being an employer's liability issue or an employer's exclusion, because if it happened at the factory, then presumably it was the insured's employee that was injured. So you'd have to factor that in as well. Is emotional injury of my spouse, family member, associate covered if it arises out of my bodily injury? That is an interesting question. That's going to be really more of a question of, the first step is whether or not your spouse or family member can even bring a claim for your bodily injury. It's very, very difficult for family members to bring a claim as a result of somebody else's injury. Usually there has to be something that happens sort of within like the zone of danger where somebody is injured, and as a result of that, a family member was in close proximity and saw the injury. So for them to even bring a claim for liability, usually there has to be within sort of the zone of danger. But there very well could be coverage for the emotional injury of a spouse, family member. There is loss of consortium type coverage out there. I guess that's one way to look at it. But I think it's more of a question of whether or not it's even going to be covered it's whether or not there's even going to be liability for that in the first place, and then looking into policy to see. You don't see those claims a lot because it is hard to bring a zone of danger claim, because it's the test for a family member being able to recover for emotional injury is pretty difficult. All right, let me try to look at this one real quick here. Bear with me for 1 second if you don't mind. Yeah, no, somebody makes a point here. In that last case, it's a defective product. No occurrence happened. Wait a minute, this moved up there. Okay, in that last case, it's a defective product. No occurrence happened. If it is at the factory, there's no BI or PD, or even if there were a BI, it would be probably to an employee. Might be a situation where you have design E&O. That's certainly a possibility. Also, at least in a CGL situation, you'd have no coverage for your own work or your own product. You have a your work or your product situation. Okay, just a note, if it was at the factory but potential injury could occur if not corrected, then likely a product recall policy could step in. I guess, assuming it's a product that's already out there, and then you have this defect that's determined, certainly if it's the first time the defect happened, then I'm not sure you'd have I guess you'd have it depends really what's out there in the marketplace already before you'd have the recall situation. Sorry, it's these things come in this little box, so I have to. Okay, got it. All right, I think that's it. The questions are tough to do. I have to apologize. It's really tough to do. I try my best. The questions in a webinar context are tough. You don't get a lot of time to think about them. So I hope I did an adequate job with the. I hope I did an adequate job in terms of answering them. If I didn't, or if somebody has one and they don't want to ask it on here, on the first slide there's my email address, so whatnot. The last thing is I'll do a self-serving promotional plug, if you don't mind, if you just bear with me for 2 seconds. The newsletter that was mentioned at the beginning, it's a real labor of love of mine. It has close to 23,000 subscribers, and it's a little bit quirky. I interview famous lawyers. I've interviewed some of the most famous lawyers in America on it. I do on every issue where I interview people. I've interviewed Alan Dershowitz. I've interviewed John Grisham, Robert F. Kennedy Jr., Attorney General Gonzalez, George Mitchell, Robert Shapiro on the OJ case. So even though it's an insurance newsletter, I've developed this niche where I interview famous lawyers. It's a lot of fun, and that part of the newsletter does not get into insurance. So it takes 30 seconds to sign up. If you're interested, just go to coverageopinions.info. It's free, and again, it goes out about once a month to about 22,000 or so people. And then again, I don't make a whole lot of money from this book, so I'm not trying to tout books, but I've written this book for the last 9 years or so. National Underwriter is the publisher right now. It's in the 3rd edition, where what we did was a law professor out in Vegas and we looked at the 21 most important liability coverage issues, the ones that arise on a daily basis, the ones that people cross their desk every single day of the week. And we looked at a 50-state survey of every single issue. So it's about 800 pages. So there's only so much you can do with a 50-state survey, obviously, but we looked at these 21 issues, and then there's about a paragraph or a half a page or so that looks at what is the law on that issue, and it's as detailed as possible for the context of a 50-state survey. We cite the key cases, the key language, and I always tell people, if you want to know why something is, if you want the technical reason why something is, buy a treatise. Don't buy my book. But if you just want to know what the answer is without all the historical background, you just want to know this is the answer to this question in this state, then that's what the book was designed to do. So, again, it doesn't make me rich, so please don't take this as a hard sales pitch. But if you go to insurancekeyissues.com, you can check out everything you need to know about it there. So thank you, everybody. I appreciate it very much. Thank you for your attention, but since I can't see you, I have no idea if anybody paid attention. But thank you. I appreciate it very much. And Courtney and Heather, thanks so much.